The Senate will come back to order. You ready to read? Mr. Secretary, will you read a series of privilege resolutions for us?
Senate Resolution 529 by Senator Harbin of the 16th and others, a resolution recognizing and commending Suzette Weinhardt for being named a finalist for the prestigious Georgia Teacher of the Year Award and for other purposes.
Is there objection to adoption of the resolution? The chair hears none. The resolution is adopted. Mr. Secretary, next.
Senate Resolution 531 by Senator Harbin of the 16th and others, a resolution recognizing and commending Real Life Center and their limitless positive impact in the counties of Fayette and Coweta and for other purposes.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. Mr. Secretary, next resolution, please.
Senate Resolution 532 by Senator Davenport of the 44th, a resolution honoring the life and memory of James Pete McQueen and for other purposes.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. Mr. Secretary, please read another resolution.
Senate Resolution 533 by Senator Davenport of the 44th and others, a resolution commending the Jonesboro High School mock trial team for winning the 2019 Georgia State Mock Trial Championship and for other purposes.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. Mr. Secretary, will you read the final resolution?
Senate Resolution 534 by Senator Hill of the 4th and others, a resolution commemorating the centennial anniversary of the city of Cobbtown, Georgia, and for other purposes. That concludes the order.
Is there objection to the resolution? The chair hears none, and the resolution is adopted. Chair recognizes the senator from the 23rd for a motion. As long as you're still the senator from the 23rd.
I think so. Mr. President, I ask for unanimous consent that HB 239 be taken from the table.
Will the Secretary please read the caption?
House Bill 239 by Representatives Abstration of the 104th and others, a bill be titled an act to amend Title 15 of the OCGA relating to courts to establish the Georgia Business Court pursuant to the Constitution of the state and for other purposes. Mr. President, the Senate Committee on Judiciary offers the following substitute to House Bill 239, a bill be titled an act to amend Title 15 of the OCGA relating to courts so as to establish the statewide business court pursuant to the Constitution of the state and for other purposes. Amendment 1 by Senator Karen Shack of the 48th offers the following amendment. Amend the Senate Committee on Judiciary substitute to House Bill 239 by replacing line 18 with the following. Service of pleadings to amend Code Section 23-3-122 of the OCGA relating to investigations by Attorney General, civil actions authorized, intervention by government, limitation on participating in litigation, stay of discovery, alternative remedies, division of recovery, and limitations so as to provide for the deeming of approval by law under certain circumstances where the Attorney General shall provide written approval for a private person bringing a civil action regarding false taxpayer claims and for other purposes. Mr. President, that concludes the order.
Senator from the 23rd has asked for unanimous consent that House Bill 239 be taken from the table. Is there objection? Chair hears none, and House Bill 239 is taken from the table. For what reason does the senator from the 48th rise?
Parliamentary inquiry.
State your inquiry.
I'd like to withdraw my amendment 1 to House Bill 239.
The senator from the 48th has asked that amendment number 1 be withdrawn. Is there objection? The chair hears none, and amendment number 1 is now withdrawn. Chair recognizes the senator from the 23rd to speak to House Bill 239.
Thank you, Mr. President. Colleagues, there's been a lot of discussion today about the business court bill. There were two versions of it, the Senate version and the House version. The Senate version started out as 110. It got stripped in the House. We disagreed and went to conference, and a committee report was submitted. There's been a lot of blowback to that committee report. So the House version that was sent to the Senate was HB 239. In Judiciary Committee, we stripped the House version out, replaced it with the Senate version, and it is the version we need to vote on today and send back to the House. It contains the two-party consent requirement that basically define the Senate's position on business courts. Be happy to answer questions, but it really needs to move on quickly.
You have a question. Chair recognizes the senator from the 45th for a question.
I'll
Mr.
submit.
Chairman, would you yield?
Yes.
Mr. Chairman, is it not true that in Gwinnett County, we have one of the most successful business courts, not just in the state of Georgia, but in the United States? And it is based on the one-party agreement system. And the bill that you're asking us to vote on is the two-party. Is that not true?
That's correct.
Would you further yield?
Yes.
Is it not true that when you go to the two-party agreement system, that there won't even be a business court because no one will take?
That's not correct. Business court is attractive to business litigants because it is expeditious and the decisions are made by judges who are expert in the area of business law. There are several different ways to get the consent under the Senate version of this. One is for the parties to contract in advance for disputes to be decided by business court. Another way is for parties after the case is filed to stipulate to be in business court. And the third way is if no objection is made to a case going to business court, it is automatic. So you have to affirmatively opt out if you don't want to be there. But two-party consent is what has historically this session been the Senate's position. Actually, it's been the Senate's position since last year. And the House was afraid there wouldn't be enough cases if you had two-party consent required. We beg to differ, and I think we'll be proven correct.
Would you further yield?
Yes.
Is it not true that they tried, I believe in one of the counties, I'm not sure if it was Fulton County, but they did try the two-party consent and they didn't have enough cases. Is that not true?
Well, they didn't give it enough time. They started in 2006, I believe, and it takes time for the word to get out and confidence to be developed in the court. Within a year and a half or so, they went to one-party consent, and so we don't really have enough experience to know. But I'll tell you this from experience as a business litigator, most business contracts today have forum selection clauses, and that's the way this court is going to grow. As people find out about it, they're going to put it in their contracts, and the contract will be the two-party consent.
Would you further yield for
Yes.
one last question? Is it not true that in Gwinnett County, we actually had corporations have a semi-headquarters in Gwinnett County so that they could try their cases in business court, and that it was based on that one consent system, and that's why it's been so successful. And even though you say that the Senate agrees with the two consent, that there's people in here who do not agree with that. Is that not true?
I have not, you're the first I've heard, but I'm sure there may be others. But this is the main divide. If one-party consent had consensus in this chamber, we would be voting on the committee report to SB 110, but it would have failed.
Senator, do you continue to yield?
I think I've said enough, but unless somebody really wants to.
Chair recognizes the senator from the 19th.
Thank you, Mr. President. Senator Yield?
Yes.
Senator, is it not true that you've worked the past couple hours to try to get an agreement from the Senate on a business court plan?
I have.
And is it not true that this plan can be the vehicle that we've already agreed with the House so they can help put language that makes the Senate feel much more comfortable with the business court idea?
The House sponsors have worked with us on this.
And is it not true that I'll be voting in favor of this bill?
Absolutely.
Thank you, Mr. Chairman.
Do you continue to yield?
I'll yield the well.
Senator has yielded the well. Any other senators wish to speak for or against the bill? Chair hears none. The question is now on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. For what reason does the senator from the 42nd rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true, Mr. President, that I'm happy to vote green on this bill? It's been a lot of work by both parties.
I'm certain the senator knows of what she speaks. On the passage of the bill, the yeas are 51, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 51st for a motion.
Mr. President, I hate to do it, but I've got to move that the Senate adhere to its disagreement to the House substitute to Senate Bill 200 and that a conference committee be approved.
Will the Secretary read the caption?
Senate Bill 200 by Senators Gooch of the 51st and others. The bill will be titled, An Act to Amend Article 4 of Chapter 2 of Title 32 of the OCGA relating to exercise of power to contract by the Georgia Department of Transportation so as to require the department to develop a procedure for appealing the rejection of a contract bid and for other purposes. Mr. President, the House offers following substitute. Senate Bill 200, the bill will be titled, and for other purposes. That concludes the order.
Senator from the 51st has moved that the Senate adhere to its disagreement to the House substitute to Senate Bill 200 and that the conference committee be appointed. Is there objection? Chair hears none and appoints the senators from the 51st, the 7th, and the 25th for a committee of conference. Chair recognizes the senator from the 46th.
Mr. President, I ask for unanimous consent that House Bill 76 be taken from the table.
Ms. Secretary, please read the caption.
House Bill 76 by Representative Stevens of the 164th and others. A bill be titled, An Act to Amend Title 3 of the OCGA relating to alcoholic beverages so as to specify that counties and municipalities may regulate alcohol licenses as to certain distances in a manner that is less but not more restricted than those distances specified by the state and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following substitute to House Bill 76. A bill be titled, An Act to Amend Title 3 of the OCGA relating to alcoholic beverages so to provide for and change certain provisions regulating the sale and consumption of alcoholic beverages and for other purposes. Mr. President, that concludes the order.
Senator from the 46 has asked for unanimous consent that House Bill 76 be taken from the table. Is there objection? Chair hears none, and House Bill 76 is taken from the table. Chair recognizes the senator from the 46 to speak to House Bill 76.
Thank you, Mr. President. This is very similar to what we just did. We had to use a House vehicle to send the House back a Senate bill. This was originally Senate Bill 146 on the wine tastings, and it has got one other provision in here that is for the city of Savannah. Once again, they have a situation down there where they have so many buildings that are owned by the Savannah College of Art and Design that it makes it hard for them to have restaurants or liquor stores or other places that serve alcohol without infringing upon the distance requirements in the code. So this is a very narrowly drafted exemption for a new convention center type place that they're trying to set up that will have alcohol connected to it. I've talked with the author in the House, and I'm fine with that, using our original Senate Bill 146 as a vehicle. I'm happy to answer any questions, or I'll be glad to yield the will.
Chair recognizes the minority leader for a question.
Senator Yield.
I yield.
So this is a separate issue than the one about the liquor store, the museum, or?
Exact same issue.
Thank you.
That's it.
You have no more questions.
Thank you. I yield the will.
Any other senators wish to speak for or against the measure? Chair hears none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 47, the nays are 9. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 51st for a motion.
Mr. President, I ask for unanimous consent that House Bill 454 be taken from the table.
Mr. Secretary, please read the caption.
House Bill 454 by Representatives Tanner of the Ninth and others, the bill be titled and enacted in Title 40 of the OCGA relating to motor vehicles and traffic, so as to provide for the operation of motorized mobility devices and for other purposes. Mr. President, Senate Public Safety Committee offers the following substitute to House Bill 454, a bill be titled and enacted in Code Section 12-3-114 and Title 40 of the OCGA relating to policies to guide Department of Natural Resources in creating and administering the Georgia Scenic Trail System into motor vehicles and traffic, respectively, so as to provide for permitted operations of electric-assisted bicycles and for other purposes. That concludes the order.
Senator from the 51st has asked for unanimous consent that House Bill 454 be taken from the table. Is there objection? The chair hears none, and House Bill 454 is taken from the table. The chair would like to recognize the senator from the 51st to speak to House Bill 454.
Thank you, Mr. President. Senators, this is a pretty simple bill before you. Thank goodness for technology. It's come a long ways. They now make electronic assisted bicycles. Believe it or not, me and the senator from the 53rd can ride a bicycle up a hill. So this bill will be basically sets up the framework for the e-bikes. You may see them in Atlanta. They're already out on the streets. This bill came through the Public Safety Committee. It creates 3 classifications for the e-bikes. It's a compromise between the industry and the local governments, and there was no opposition to the bill. We do want to come back over the summer and study the e-scooters and come back to you next year with some language on those as well. Mr. President, I'm happy to yield for questions.
You have no questions.
Thank you.
Any other senator wish to speak for or against the bill? Chair hears none. The questions on the adoption of the committee substitute. Is there objection to adoption of the committee sub? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? The questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 29th for a motion.
Mr. President, I ask for unanimous consent that House Bill 543 be taken from the table.
Mr. Secretary, please read the caption.
House Bill 543 by Representative Illustration of the 104th and others, a bill be titled enactment, Article 1 of Chapter 7, Title 19 of the OCGA, relating to general provisions regarding parent and child relationship generally, so as to provide for equitable caregivers and for other purposes. Mr. President, the Senate Committee on Judiciary offers the following substitute to House Bill 543. Bill be titled enactment, Article 1 of Chapter 7, Title 19 of the OCGA, relating to general provisions regarding parent and child relationship generally, so as to provide for equitable caregivers and for other purposes. Amendment 1 by Senator Brass of the 28th and others offers the following amendment. Amend the Senate Committee on Judiciary substitute to House Bill 543 by replacing lines 53 and 54 with the following: was fostered or supported by parent of the child and such individual and the parent have understood, acknowledged, or accepted and for other purposes. Mr. President, that concludes the order.
Senator from the 29th has asked for unanimous consent that House Bill 543 be taken from the table. Is there objection? Chair hears none, and House Bill 543 is removed from the table. Chair recognizes Senator from the 29th to speak to House Bill 543.
Thank you, Mr. President. Fellow senators, I come to you with, without a doubt, the most compassionate piece of legislation that I've had the opportunity to discuss during this session. House Bill 543 is a common-sense approach to tackling a rare circumstance that occurs in our courts when an individual is serving in a parental role but has no legal authority to do so. And in these cases, which are limited circumstances, this legislation gives the judges the opportunities to address the issues that are important to those individuals who have been brought into these children's lives by their parents. I was approached in the hallway by a gentleman that just impacted. He and a young lady he started to date weren't able to get married because she was going through the adoption process of a child from China. She could not get married to him because she could not afford to have a name change and have the process start over. Once the adoption was final, they did have a formal marriage. They were married for 9 years, and when they got divorced, he had no parental rights to the child that he had raised for 9 years. This will help with that. The bill in front of you has a pro se petitioner on the second and third page, and one of the very most important parts of this legislation is found in paragraph D on line 91, where the Georgia Supreme Court codified 5 determining factors that the court will use to determine standing for the equitable caregiver. The amendment that inadvertently was actually, it's the amendment should be mine and not the senator from the 28th, but the amendment cleans up some of the language in the first part, and in the second part it codifies some of the case law from Clark v. Wade, which deal with some of the harm definitions, and it creates a consent mechanism for a parent who may be suffering from a debilitating disease such as cancer, MS, or something else. And I encourage each of you and pray that each of you will support this legislation. And if there aren't any questions, Mr. President, I yield the well.
You have a question. Chair recognizes the senator from the 20th for a question.
Senator, would you please yield?
Yes, sir.
This is a good bill. I just am curious. I would like you to please distinguish between a formal marriage and an informal marriage.
The informal marriage was a ceremony held at their church, but it was not a legal marriage. Thank you, Senator.
Chair recognizes the minority leader for a question.
If the Senator could you once again highlight your amendment just a little bit as I look at it? Yes, sir. The first part of the amendment cleans up and clarifies the language in the substitute, and the second part of the amendment does 2 things. It codifies case law from the Clark v. Wade, and I'll pull the amendment out real quick, if you don't mind. And in Clark v. Wade, you'll see on line 10E, in determining the existence of harm, the court shall consider factors related to the child's needs, included but not limited to who are the past and present caretakers of the child, with whom the child has formed psychological bonds and the strength of those bonds, whether the competing parties evidenced as interest in, with contact with the child over time, and whether the child has unique medical or psychological needs that one party is better able to meet. That's the primary part under that case law, determining the harm caused to the child if the child's removed from one parent and taken away from another person, caregiver.
Senator, further yield?
Yes, sir, I will.
Had the subject matter of the amendment been discussed as it went through the committee process, or is this something that you realized later on that was something that was pertinent and needed to be added?
After speaking to some of the attorneys that were involved in judiciary, it was determined that this would help clear up some language, primarily the fine senator from District 17.
Senator, further yield? Have you talked to the House sponsor about this amendment, and do you know the status of the response of the House?
Yes, sir, and the House sponsor is extremely excited about this and is as passionate, if not more, than I am. Thank you, Mr. President. I yield the well.
Senator has yielded the well. Chair recognizes the senator from the 28th to speak to his amendment. Senator from the 28th, he waives. He waives. Any other senator wish to speak for or against the measure or the amendment? Chair hears none. We'll take up amendment number 1. The question is on the adoption of amendment number 1. Is there objection to the adoption of the amendment? Chair hears none. The floor amendment is adopted. The question is now on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Senate will come back to order. Senate will come back to order. Chair recognizes the senator from the 9th for a motion.
Mr. President, I move that the Senate adhere to its disagreement to the House substitute to SB 214 and that a conference committee be appointed.
Mr. Secretary, please read the caption to Senate Bill 214.
Senate Bill 214 by Senators Martin of the 9th and others. The bill will be titled an act to amend Chapter 10 of Title 43 of the OCGA relating to barbers and cosmetologists so as to change the number of apprenticeship hours required for cosmetologists, hair designers, estheticians, nail technicians, master barbers, and for other purposes. Mr. President, that concludes the order.
Senator from the 9th has moved that the Senate adhere to its disagreement to House Substitute Senate Bill 214 and that a conference committee be appointed. Is there objection? Chair hears none and appoints the senators from the 9th, the 47th, and the 1st as our conferees. Chair recognizes the senator from the 22nd for a motion.
Mr. President, that I move that the Senate agree to the House substitute to SB 9 as amended by the Senate.
Mr. Secretary, please read the caption.
Senate Bill 9 by Senator Jones of the 22nd and others. The bill will be titled an act to amend Part 3 of Article 3 of Chapter 11 of Title 16 of the OCGA relating to invasion of privacy so as to prohibit sexual extortion and for other purposes. Mr. President, the House substitute to Senate Bill 9. A bill will be titled an act to amend Title 16 of the OCGA relating to crimes and offenses so as to revise the crime of sexual assault by person with supervisory or disciplinary authority and for other purposes. Amendment 1 by Senator Jones of the 22nd and others offers the following amendment. Amend the House substitute to Senate Bill 9 by deleting tongue on line 30 and for other purposes. That concludes the order.
Chair recognizes the senator from the 22nd to speak to his motion.
Thank you, Mr. President. This is a bill that passed out of the Senate, originally SB 9. It is still in there in Section 2, and that passed out of the Senate, I believe, unanimously. And that particular part of the bill deals with sexual extortion, where persons are extorted to give compromising photos of themselves through the use of threats. The House has actually also added an amendment to this, and what they have done is amended Official Code of Georgia annotated 16651, which deals with supervisors. Basically, we do not want, this is already current law, we do not want persons to have sex or sexual contact with students. We do not want them to do the same with persons who are in hospitals, persons who are receiving therapy, or persons who are being detained by law enforcement. And they did two things. Number one, they basically just cleaned up that language. Instead of listing all of those things, they said if you're an employee or an agent, that you cannot do those things. And then secondly, they separated that into degrees. The current law today is if you have sexual contact with somebody and it's a student or a person in a hospital, it's 1 to 25 years. Sexual contact, not sex, just sexual contact. So the House did 2 degrees, 1 degree of sexual contact, which can make it a higher and aggravated misdemeanor, and then the second one, of course, is actual sex, which could be a felony. The amendments that you have are friendly amendments. They're by myself and a senator from the 42nd. They have been agreed upon by the House sponsor. And the first is by deleting the word tongue on line 30. They had actually decided that tongue was an intimate body part. We deleted that. Intimate body parts will stay intimate body parts. And then the second is to just keep the fine at its current level, which is $100,000 if you are convicted of a felony. They had lowered it to $50,000. We kept it at its current level. That is an amendment by myself, and I'll be glad to take any questions if any are available, Mr. President.
You have a question. The chair recognizes the senator from the 23rd.
Thank you, Mr. President. Will the senator yield?
Yes.
Isn't it true that the amendments offered significantly improve the House changes to OCGA 16-6-5.1?
Absolutely, Senator, because number one, it keeps intimate body parts, but number two, I should also state that the current law was not that a person had to be placed on the sex registry, and we kept that current, and that was important to various members of the Senate, but we kept the fine also at its current point. So the current law is staying where it is. So I think it improved that particular amendment, and we can go forward from there.
You have no more questions.
Oh, thank you, Mr. President. You will.
Any other senator wish to speak for or against the measure or the amendment? Chair hears none. The senator from the 22nd has moved that the Senate agree to the House substitute to Senate Bill 9 as amended by the Senate. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the motion, the yeas are 51, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 9 as amended by the Senate. Chair recognizes the senator from the 18th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 190.
Mr. Secretary, please read the caption.
Senate Bill 190 by Senator Kennedy of the 18th and others, a bill be titled enactment Article 2 of Chapter 9 of Title 19 of the OCGA, relating to the Child Custody Interstate Jurisdiction Act, so as to provide that a party may bring a counterclaim for contempt or enforcement of a child custody order or for modification of legal or physical custody in response to a complaint seeking a change of legal or physical custody and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 190, a bill be titled enactment Article 2 of Chapter 9 of Title 19 of the OCGA, relating to the Child Custody Interstate Jurisdiction Act and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 18th to speak to his motion.
Good evening, colleagues, and thank you, Mr. President. Bring to you Senate Bill 190. This is the bill that I brought to you some weeks ago, and it, in essence, allowed for cases involving domestic relations where the child custody matter was filed to allow for a counterclaim to be filed. That's the one exception under our Civil Practice Act where the litigants, where one is suing the other, that the second can't sue, the defendant can't counterclaim against the plaintiff. We passed this with good support, went over to the House. There was one change that was made to the bill before I presented it to you, as from the way it was initially filed, and we sought to correct a potential question of whether or not the bill addressed contempt actions. So we removed some language to try to make it clear that, in fact, in contempt actions, you still have that limitation such that you cannot file a counterclaim in a contempt action. That has some potential constitutionality issues. But the language that we sent over to the House, they further mused on it and were concerned that there still was some issue. So what you have really at the bottom of the bill is the important parts in line 50 retains what we intended to do, which was simply that a party may bring a counterclaim for modification of legal custody or physical custody in response to a complaint brought under this subsection A of this code section. But the earlier language makes clear that it does not involve or touch upon in a contempt action. So they clarified to the extent that there was any question with the language that was left, it was simply clarified. The intent of the bill is still satisfied with what you voted on and what was represented to you at the beginning. I'll be happy to answer any questions.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the senator yield?
I do, to my good friend from the 48th, and I'll go ahead and tell you, Senator, there's no fiscal impact
Great, thank
of
you.
this
I
bill
appreciate
on the
that.
great treasury of the state of Georgia.
I appreciate that. I have to admit, when you're talking about the contempt part of this bill, if you could look at lines 46 and 47.
Okay.
That seems to say you cannot bring a contempt action. Is that what we're trying to do?
I'm sorry.
It appears that lines 46 and 47 say we cannot bring a contempt action. Is that what we're trying to do with this bill?
Well, we're trying to make sure that you can't counterclaim in a contempt action, and there was some question about the prior language. We thought we cleared it up and made it clear that that is in fact what we were not doing that with the bill, and we were limiting it only to the issue of counterclaims in child custody matters, and that you wouldn't let that extend over into a potential contempt action.
Okay.
And
well,
so they've clarified it that way, and I think if you begin, Senator, if you'll read starting at line 42, which says no complaint specified in subsection A of this code section shall be made in response to, and then you drop down to the lines you're asking about, which would be any other action or motion seeking to enforce child custody, including but not limited to a motion for contempt. So when you read line 47 referencing motion for contempt, back up to line 42 saying that no complaint shall be filed, that clarifies that you don't and cannot file a counterclaim in a contempt action.
and that's what I wanted to make sure.
Yes, ma'am.
Okay, thank you.
Thank you. I appreciate
You
the
continue
question.
to yield?
Sure.
Chair recognizes the senator from the 23rd for a question.
Thank you, Mr. President. Will Senator yield?
I do, for the good rules, good chairman of the judiciary.
I don't want to put you on the spot, but what would be left to counterclaim against if you rule out contempt actions?
It could be any action, well, if you had an action for child custody modification.
Okay.
You have no more questions.
Thank you. I urge your support.
Any other senators wish to speak for or against the motion? The chair hears none. The senator from the 18th has moved that the Senate agree to the House substitute to Senate Bill 190. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 52, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 190. Chair once again recognizes the senator from the 18th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House amendment to the Senate substitute on HB 424.
Ms. Secretary, please read the caption.
House Bill 424 by Representative Silcox of the 52nd and others. The bill will be titled an act to amend Code Section 16-15-3 of the OCGA relating to definitions regarding street gang terrorism and prevention so as to include certain sex crimes into the definition of criminal gang activity for other purposes. Mr. President, the Senate offers the following substitute to House Bill 424. A bill will be titled an act to amend Title 16 of the OCGA relating to crimes and offenses so as to repeal an enhanced penalty relating to battery against a person 65 years of age or older and for other purposes. Mr. President, the House offers the following amendment. Amend the Senate substitute to House Bill 424 by inserting after persons on line 4 the following to revise penalties related to trafficking of persons for labor, sexual servitude, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 18th to speak to his motion.
Thank you, Mr. President. Again, good evening, colleagues. This is a House amendment made to our original Senate substitute to HB 424. Simply does some cleanup work to the sentencing provisions for trafficking of sexual servitude. It revises penalties related to the trafficking of persons for labor and sexual servitude. SB 158, the Anti-Human Trafficking Protective Response Act, which is now in final passage, provided for stricter penalties for trafficking for sexual servitude, especially when the trafficking victims are minors. The House amendment to HB 424 removes some conflicting sentencing provisions for trafficking for sexual servitude. Otherwise, the bill remains intact as we voted on previously.
Senator, do you yield for questions?
I do.
Chair recognizes the senator from the 45th for a question.
Will the senator yield?
I do, for the good
Senator,
chairman.
is it not true that this is just a cleanup and that we're actually doing a great job on the issue of human trafficking and this will make us more efficient and effective?
I could not agree more, Senator, and I appreciate the question and also appreciate the opportunity to once again thank you for your leadership on this issue for the Senate body and for the state of Georgia.
You have no more questions.
Thank you. I yield the well.
Any other senators wish to speak for or against the motion? Chair hears none. The senator from the 18th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 424. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 53, the nays are 0, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 424. Chair recognizes the senator from the 23rd for a motion.
Mr. President, I ask for unanimous consent that 492, HB 492, be taken from the table.
Mr. Secretary, please read the caption.
House Bill 492 by Representative Rich of the 97th and others, a bill be titled enactment Article 3 of Chapter 7, Title 44 of the OCGA, relating to dispossessory proceedings so as to require applications for execution of writ of possession be made within 30 days of the issuance of the writ unless good cause is shown for other purposes. Mr. President, Senate Committee on Special Judiciary offers the following substitute to House Bill 492. A bill be titled enactment Article 3 of Chapter 7 of Title 44 of the OCGA relating to dispossessory proceedings so as to require applications for execution of writ of possession be made within 30 days of the issuance of the writ unless good cause is shown for other purposes. That concludes the order.
Senator from the 23rd has asked for unanimous consent that House Bill 492 be taken from the table. Is there objection? Chair hears none, and House Bill 492 is taken from the table. The chair recognizes the senator from the 23rd to speak to House Bill 492.
Thank you, Mr. President. Colleagues, all this bill does, it's at the request of the magistrate judges to require people to send their writs of possession for execution within 30 days. That is, to take your writ of possession to the sheriff or whoever's executing it within 30 days and not sit on them. The judges complain when people don't act on writs of possession for many months after they're issued. Circumstances change, and this prevents abuse of writs of possession. Be happy to answer any questions.
You have no questions.
Urge support for HB 492.
Any other senators wish to speak for or against the bill? Chair hears none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question's on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 50, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 25th for a motion.
Thank you, Mr. President. I ask for unanimous consent to have House Bill 490 taken off the table.
Ms. Secretary, please read the caption.
House Bill 490 by Representatives Ridley VI and others, a bill be titled and acted in Part 12 of Article 1 of Chapter 1 of Title 7 of the OCGA relating to deposits of deceased depositors so as to make changes relating to the payment of large deposits of deceased interstate depositors and the deposit of sums held for deceased interstate residents and for other purposes. Mr. President, that concludes the order.
Senator from the 25th has asked for unanimous consent that House Bill 490 be taken from the table. Is there objection? Chair hears none, and House Bill 490 is taken from the table. Chair recognizes the senator from the 25th to speak to House Bill 490.
Thank you, Mr. President. House Bill 490 came from the Banking Committee. It's a rather simple bill. It deals with a deceased party that does not have a will. This is usually a tool. It's going to be a tool used for mostly funeral homes or medical facilities. They're looking to pay for the debt of this individual. They have to, in order to access funds from a person who does not have a deceased person who does not have a will, they'll have to have a signed affidavit to present to whatever financial institution to satisfy their debts. If there's no questions, Mr. President, I yield the will.
You have a question.
Yes,
Our
sir.
good friend from Gwinnett County from the 48th District has a question.
Oh, absolutely.
Thank you, Mr. President.
Yes.
Does the chairman yield?
I do.
I'm trying to understand, why do we need House Bill 490?
That's a great question, and you'd have to ask the author from the House because I actually don't even know why I was asked to carry this, but but I'd love to be able to answer that for you. But it looks like it's just raising the minimum limit from $10,000 to $15,000, and I guess it's in cases where a family that or an individual who does not have a succession in plan and they have debts that need to be paid. This is for the funeral home types or the healthcare facilities to be able to try to access those funds to have those debts paid that they're owed.
Does the chairman further yield?
I will.
So that means the estate of the deceased would be able to be tapped at a higher amount. Am I fair in saying that?
If you had an independent, attorney that gets an affidavit signed by the necessary, I'm sure it'd have to be signed by courts and go through a magistrate or superior court process. I wish I knew more, Senator, but I'll probably yield to the chairman of that committee to answer some of those questions.
Thank you, sir.
Mm-hmm. Sure, you can. I mean,
You have no more questions. Oh, Chair recognizes the senator from the 3rd for a question.
Thank you, Mr. President. Senator, does the senator yield?
please help me out here.
Just quickly,
Chairman.
isn't it true that, as you said, under existing law, either a family member's surviving spouse or the children or funeral home can sign an affidavit and withdraw the money from a bank account held by
The chairman
deceased.
knows is
And
what
this
he
is
speaks.
just increasing that to $15,000. And isn't it true also that this is providing the format for the affidavit that should be filed to ensure that no one takes advantage of
The
this
chairman
system?
knows what he speaks.
Thank you.
You have no more questions.
Thank you.
Does any other senator wish to speak for or against the bill? For what purpose does the senator from the 14th rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, I ask unanimous consent to be excused from voting on HB 490 pursuant to Senate Rule 5-1-8.
Senator from the 14th is asked to be excused from the vote. Is there objection? Chair hears none, and the senator from the 14th is excused. Does any other senator wish to speak for or against the bill? Chair hears none. The previous questions ordered. Is there objection or agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 43, the nays are 7. This bill, having received the requisite constitutional majority, is therefore passed. Chair would like to recognize the Sergeant at Arms. Mr. Sergeant at Arms, please allow the governor to enter the chamber. It is my honor to be able to introduce this chamber. Governor Brian Kemp had the honor of introducing the First Lady several weeks ago, and just like myself, the best thing about us are our wives. Our families have gotten to know each other really well, and it has been an honor for the last 40 days to work side by side with this governor. It is an honor to introduce Brian P. Kemp to this chamber.
Thank you, sir. Thank you very much. Thank you all very much. Thank you. Y'all are very kind. It's an honor for me to be back in the body where I once served, sitting in the back of the room, representing the 46th District. So I have been where you are on this day many years ago. But I just wanted to come by real quick and just thank you for your service to your district and to our state. That does not... I do not take that lightly. I know it's a very important job that you're doing. I know you spend a lot of time on it, and I know you work hard to represent your folks back home. And it's been an honor to serve with you this legislative session. I also want to thank all the Capitol staff for what they do in the background of this process to make this process work. I also want to thank our Capitol security and all of those that keep us safe and get us in and out of the building. Certainly want to thank all the hard-working pages. I had a page tell me earlier when we were taking a picture they had heard a rumor about us or you all getting out early tonight. I told them not to believe that rumor. I also told somebody earlier, I thought the only people that are probably more excited about session being over than myself is the folks in Legislative Council. So I want to thank them as well for their service. And being that I realize you all represent a district back home, and those districts have different constituencies, you know, I have great appreciation for that. But I think all Georgians can be proud of this great state of Georgia and this body's broad bipartisan support on our balanced budget. So congratulations to you all on that. And I think that is a budget that is putting Georgians first, and that's really the most important thing that we do here. I know you're very busy. I'm not going to talk long. I just wanted to come by and say we have great appreciation and thanks for your service to your district and to your great state. Thank you, and God bless you. Good luck the rest of the way.
Can you stand at ease for 10 minutes? Go down. Yeah. Good or no? Yeah.
Thank you, Governor. The Senate will stand at ease for 10 minutes. The Senate will stand at ease for 10 minutes.